Good evening, ladies and gentlemen. Welcome to Talk Law with Monare. My name is Monare and I'm your host. So tonight we'll be talking about, we'll be taking a detour. So we are launching our labor law series. So tonight is our first episode where we'll be doing just introductions into South African labor law. So because the reason we chose to launch this series is that we figured that the South African labor market is going through a lot, both employers and employees alike. So we decided to take a detour from our normal discussions, and so we figured that, you know, these are tough times, so we need to keep providing content that speaks to people. So I mean, the State South Africa recently just announced in August that the unemployment rate is at 34.4%. So we decided that, you know what, the labor market is going through a lot, and a lot of people are losing their jobs, some unfairly so. A lot of employers are unable to cope with the workplace demands, be it things like having to retrench people, having to accept staff which is not vaccinated, you know, such things. So we figured that let's move away from some of the fields that we've been discussing and actually come into the field of labor law, you know. Not to say that other fields of law are not important, but then we figured that we need to speak to something that a lot of people can relate to at this current moment. So without further ado, let's walk into our conversation for tonight. So the first question that we'll be dealing with is what is labor law? You know, because we just hear that there's labor law, there's labor, but then we often don't really know the definition of what labor law is. So the first part of our discussion will be dealing with, I will be answering that question. Exactly what does labor and employment law refer to? And then from there we'll be moving to the purpose. What is the purpose of labor law or labor and employment law in the society, but in particular in the labor market? So labor law refers to a system of rules and regulations, or it refers to a system of rules regulating employment and employment relationships and work or labor. So this set of rules, it regulates various relationships. Some of these relationships is a relationship between employer and employee, between employee and trade unions, between employer and employer organizations, between employer organizations and trade unions, between trade unions and trade unions alike, and so these various relationships in labor law, they have their own set of legislation. You know, for instance, when you are dealing with employer-employee relationship, it's largely governed by the Labor Relations Act. And then you move to the prospective employer and then job applicants. You find that the legislation that really covers that sort of relationship is the Employment Equity Act. And then you have the Basic Conditions of Employment Act, which it governs all types of employment and working relationships. So there are various other legislations, like for instance, you have the Occupational Health and Safety Act, which regulates how the health standards and the safety protocols that employers are supposed to abide by in the workplace. So it's this act and a number of other acts together, they form this system of regulations, which then becomes labor law. So labor law, it's a collection, or it's a collective of these legislations. Employment contracts are like, so basically you'll also have the aspects of contract law in it. So now, but then all these acts they make what we call the labor law system. So labor law again refers to a system of regulating the relationship between employer and employee, but then it also includes job applicants. And in those, there are other role players, as we've already mentioned. You'll have trade unions and employers organizations. You'll have government departments and all of that. So, but basically labor law refers to it. It's just the system which seeks to govern the relationship between the employer and the employee in most cases. So the second question that we have to move to now is, what is the purpose of labor law in the society at large, but in particular in the South African labor market? So we've already somehow tapped into the purpose, because we mentioned that it's a system that regulates the labor market. So an economy, as part of the state establishment, it survives on the back of its labor force. The labor force refers simply to people who work. So now, with that being the case, one may then argue that the labor force ought to be the most regulated, the most protected, the most promoted and preserved part of the society. And by the way, when we say the labor force, we are referring to all types of employees and employers. So it can be from farm workers, domestic workers, taxi drivers, defense services, which include subs, security officials, the police, to CEOs, lawyers, accountants, teachers, nurses, and doctors, and everyone. So the labor force refers to all the workers and all the employers without any discrimination thereon. So it goes without saying that any relationship that does not have rules and regulations is actually bound to fail. So, I mean, an example could be Mujolo. You know, Mujolo also needs to be regulated, because if you have, or rather if you are in a Mujolo, but you don't have rules and you don't have regulations, you don't have ground rules that govern the relationship, then the relationship is bound to fail. You know, so all types of relationships need to be regulated. There needs to be a set of rules which govern that relationship. So the labor market or the employment relationship is no exception, because it's a relationship between the employer and the employee, or the employer and the person who is applying for a job, or between employers organizations and trade unions. But all this type of relationships, they need to be regulated, because because in regulating them, the legislator will then be ensuring that the employers will not be unfairly treating the employees, but at the same time, the legislator will be ensuring that employees will not be abusing their rights. So the best thing about the South African labor law system is that it is based on the principle of social justice and the principle of fairness. So in brief, because our next session, the next episode will be discussing the development or rather the historical development of the South African labor system, as well as these principles, the principle of social justice, as well as the principle of fairness. So the South African labor law is based on those two principles as its core pillars. You know, so in brief, these principles, they recognize and they take into consideration the country's political and economical and social, as well as cultural history in, when a decision maker has to adjudicate over a matter. So we will expand on these principles, but the principle of fairness, for instance, it actually states that everyone must be treated fairly. When in lawyers would note that in the criminal justice system, for instance, we are talking about guilty or not guilty. The test which we use is beyond reasonable doubt. So there must be no doubt before you can find someone guilty, or there must be no reasonable doubt before you can find someone guilty of a crime. So the system in criminal law is a bit more, one may say, more formalistic or more rigid or more complex. So labor law, it lies on the shores of fairness. What is fair in these circumstances? So that's one of the pillars. And then the second pillar would be the principle of social justice. So in brief, the principle of social justice simply refers to, or rather states that everyone must have access to the law, the labor law being no exception. Everyone must have access to the tribunals. That is why in section 23 of the South African constitution, which I have right here, it states that, let me just read it for you. So section 23 of the constitution states that, and by the way, it's the same section that gave rise to the Labor Relations Act. So the Labor Relations Act was brought into force through section 23 of the Constitution. So section 23, which is, the heading is labor relations. It says everyone has the right to fair labor practices. And then it further states that every worker has the right to form or join a trade union, to participate in the activities and programs of a trade union. And then in subsection 3, it says every employer has the right to form and join an employer's organization and to participate in the activities and programs of an employer's organization. In subsection 4, it says every trade union and every employer's organization has the right to determine its own administration, and so forth and so on. So the Constitution provides for fair labor practices. And as we've already highlighted, the labor system in South Africa is based on the principles of fairness, the principles of social justice. So how does the South African government then provide for the realization of the principle of social justice? Because the principle of social justice states that everyone must have access to the law. Everyone must have access to legal services. So you have institutions like the CCMA. So the Commission for Conciliation, Mediation and Arbitration, the CCMA, is a Section 9 institution, like the Public Protector's Office and the Equality Commission and the Competition Commission. So the CCMA was formed to provide the access that is spoken to by the principle of social justice. That is why when you go to the CCMA, it's a non-paying service. The CCMA does not charge any fees to adjudicate over a matter, and the CCMA doesn't represent the employee and the employer, or the employer, contrary to popular belief, because there is a misconception that the CCMA represents employees, or is it acts on behalf of employees. A lot of people go to CCMA to obtain their services with the understanding that the CCMA is their lawyer, whereas that is not the case. The CCMA is a commission that is formed, and its main its main function is to adjudicate over labor disputes, to mediate over them, and to arbitrate. So that is how then the government or the labor force or the labor market is then being provided with social justice. So when you get to the CCMA, as I already said, in criminal courts, you find that the rules are a bit more complex for the layperson to understand. So the labor law, because it seeks to achieve social justice and fairness, section 135 of the Labor Relations Act states that, let me just read the section for you. It's section 135 of the Labor Relations Act. So it states that the heading is a resolution of disputes through conciliation. So it says when a dispute has been referred to the commission, it refers to CCMA. The commission must appoint a commissioner to attempt to resolve it through conciliation. The appointed commissioner must attempt to resolve the dispute through conciliation within 30 days. However, the parties may agree to extend the duration. So there's a particular section or subsection that I want to go to, just to make my point much clearer. But basically, the Labor Relations Act states that the commission, the CCMA, and even bargaining councils, when they are resolving disputes, they must do so with minimal formalities, minimal legal formalities, and minimal legality. So what that means then is that the processes at the CCMA, they are, especially conciliation, they are more informal in nature. They are more relaxed. There is no legal jargon, because that is still to achieve fairness. Because remember, a commissioner would be dealing with a case involving a farm worker, for instance, someone who has never been in a court of law, someone who may not probably have a legal background, versus a large corporation. So how then do you ensure that the process is fair to the other side, being the farm worker or the domestic worker or the driver who doesn't have legal skills and legal knowledge? So you achieve that through the provision of a commission, or rather the provision of an institution like the CCMA, which deals with its cases with minimal legal formalities. So that is those are the principles that the South African labor market is based on, or rather the South African labor law. It's the principle of fairness and the principle of social justice. It's the two pillars which are holding the South African labor law. So, but that's labor law for us in brief. So our upcoming episodes will be expanding, because labor law is a very it's one of those fields of law which are continuously developing. The labor court, the labor appeal court, even the CCMA and various bargaining councils, on a daily basis, they give out awards and they give out judgments which change the law, which develop the law. Like for instance, now we have a situation where I've just seen a news headline that the government apparently wants to force public servants, teachers, to vaccinate, or they're going to have to retrench them. So these are developments. These are ongoing developments, because we are dealing with an issue of a pandemic and a vaccine. There is no law which regulates vaccine in the workplace as it stands. So, but next week we might have a new case law, or we might have new regulations, or we might have an amendment to the Labor Relations Act to Employment Equity Act to Basic Conditions of Employment Act. So labor law is that part of law which continuously, in fact, on a daily basis, it keeps developing. With a new case, there is new laws. With a new systems like the fourth industrial revolution, the digital era, we have new laws, you know. So because I was saying to someone the other day that we have people who have been working from home since last year, and if you check the Basic Conditions of Employment Act, there is a section in it where it refers to the workplace, that in the contract of employment, or rather the workplace must be clearly defined. Where exactly is the workplace, you know? So if, for instance, you're hiring me to be a lawyer, where am I going to be stationed? Because the importance of that is so that the employer is able to regulate the working relationship. It's so that the law itself can be easily applied in terms of regulating the relationship. For instance, if we say this is the workplace, this space is the workplace, and we go a step further to say we don't smoke in the workplace, then I know I don't smoke in this space which has been clearly defined as a workplace. But now, since last year, people are working from home. In the fourth industrial revolution, people will be working more remotely. So that then begs the question to say the Basic Conditions of Employment Act, as it stands, this one, which was first passed in 1997, and then it's been amended countless number of times since then. So it needs to be amended. There needs to be amendments now, because if, for instance, I'm working from home, what is the workplace? Is the workplace my office or the office that I normally travel to? Or are you going to count my kitchen and my toilet as a workplace? You know, so that's what I'm saying. Labor law is that field of law which continuously develops. You know, so we now need new amendments to define what is a workplace. You know, so that is why we saw a need to launch this series, because it's one of those fields of law which you cannot discuss in one episode. Even if we were to take the next 5 hours, we would still not have covered labor law in its entirety. So it will be a long series, but we'll try to keep it shorter for enjoyment. But at the same time, we'll incorporate legal developments as and when they happen. You know, so we'll be discussing the public wage disputes. We'll be discussing vaccination in the workplace. We'll be discussing whether people can be fired for their participation in the looting, or people can be fired for their social media posts. You know, so we'll be expanding on all of these issues during the series. So, but that was our first episode. We had to explain, to lay the foundation by explaining what is labor law, and by also tapping into its importance to the society in general, but also to the workers and the employers in particular. So thank you guys for tuning in. We appreciate your support. We appreciate you taking your time, joining us every Thursday evening. We hope to see you again, same time, same place, next week. And please go and subscribe to our YouTube channel, which is called Talk Law with Monare. Just go to YouTube and search Talk Law with Monare. You'll find our previous episodes, and just tap into the channel, subscribe, and comment give us your views in the comment section, but also hit the notification button so that you can access our content as soon as we upload it. And our Facebook page is Talk Law with Monare. So you just go to Facebook, you search Talk Law with Monare, and then there you'll also find our schedules and the link to our various pages. My name is Monare and I'm your host. This is Talk Law with Monare. Thank you. Have a lovely evening. And remember, the law is for justice, the law is for reparation, and the